with the existing needs of this constantly increasing population by various means: greater efficiency and use of water, water transfers, water banking, and the use of more surface and underground storage of already developed supplies, for example, like the Metropolitan Water District's terminal facilities. With millions more people due to arrive over the next 2 decades, however, the water shortage we will face in the years ahead will be significant. And with few new water projects on the horizon, the only way that we will survive is to make even greater use of the techniques that have carried us through the last 30 years. But more than that, we need to think, as the Governor's Commission did, about fundamentally modernizing California water rights law and policy to deal with the ever-increasing demand for what is becoming an increasingly scarce resource. We need to think about what ought to be and what we can do to achieve it. Now, in considering the future of water law and policy in California, we need to ask ourselves several different questions. First, how can lawmakers, legislators, help the state with these increasing needs, both for consumptive and non-consumptive uses? Secondly, how can administrators, specifically the State Water Resources Control Board, employ its powers, particularly in the event there's an absence of legislative initiative, to help the state achieve the best in water law and policy? And third, how can lawyers, the attorneys practicing water law throughout California, best emulate the example Anne set in her practice to help their clients achieve their private goals while simultaneously achieving what is also in the public interest of all Californians? Addressing the first question first, what can the legislature do? My thoughts return to the recommendations of the Commission and the report issued in 1978. The report identified 4 aspects of California water rights law and administration that could be improved with legislative action, specifically the certainty of water rights, and that also includes groundwater rights, even though groundwater is a separate topic. Water use efficiency, including water transfers, the protection of in-stream uses, and groundwater management. And the report included the text of specific legislation the Commission proposed in each area. You might recall that the groundwater proposals alone ran 80 pages. Unfortunately, and much to my regret, the legislature largely ignored the Commission's legislative recommendations. In 2005, the McGeorge Law Review published a symposium issue devoted entirely to the 25th anniversary of the Commission's report. One of the participants, Professor Brian Gray of the UC Hastings College of the Law, noted in his article that the report's recommendations on in-stream use and groundwater, the ones that Anne wrote, were ahead of their time. I agree, but I say their time has now come. At the very least, it is time, a long past time, for legislators, administrators, and water lawyers to reconsider the Governor's Commission's recommendations as a step toward moving California water law in policy into the 21st century. And I can only add a comment that I've been working as part of my side duties as an appellate judge to try to mediate a groundwater adjudication in Southern California. And you know, the fact that we don't have enough knowledge about what people are in fact pumping, the fact that we have to spend a lot of time adjudicating issues by finding out what we're adjudicating, the fact that we have such a dearth of requirements to know what's going on, that the Governor's Commission, had they been adopted 20, 30 years ago, would be in place today, would have made this stuff immeasurably easier to accomplish. Recently, a committee of the National Research Council, and Jerry Gilbert, one of the authors, is out there, issued a report on the Bay Delta, which includes the following statement. The committee recommends California undertake a comprehensive review of its water planning and management functioning and design modifications to existing responsibilities and organizations that will anticipate future needs. These needs include dealing with scarcity, balanced consideration of all water use practices and water engineering alternatives, and adaptive management that can adjust to changing conditions. If any such comprehensive review is to be undertaken, the recommendations from the Governor's Commission that have largely lain dormant for the past 35 years would be a good place to start. In his article for the McGeorge Symposium on the Governor's Commission, UC Davis Professor Emeritus Hap Dunning, who served as the staff director to the Commission, noted that one of the factors contributing to the immediate failure of the Commission's legislative recommendations back when they were first made was that various interest groups opposed the recommendations almost in their entirety, preferring to press, with little success I might add, for the approval of new water projects in the wake of the 1976-77 drought. Indeed, John Bryson and I warned the Governor that these interests when we first recommended the establishment of the Commission. And I recognize that even today, more than 30 years later, with all the water that has literally and figuratively passed under all the bridges in our state, there continue to be interests like those within the state that will continue to advocate for the status quo in water rights and policy, even in the face of exploding population, as well as the expanding recognition of environmental values these resources have. In the face of such inertial forces, California's water law community might well be tempted to set its sights too low, to strive for something less than the sort of comprehensive review the National Research Council Committee has recommended, something less than the fundamental changes the Governor's Commission proposed. But in Ann's spirit, I encourage those who seek the best for California's future not to be held back by those who are too much vested in what has been. If we are to achieve substantial legislative reform in the area of California water rights law and policy, we must keep our focus on what ought to be. Now, turning to the second question I posed, what can the Water Board do? My thoughts turn back to the origins of the board. It was in the late 1960s when I was working as the staff for the Assembly Water Committee chaired by Assemblyman Carly Porter, the author of the Burns-Porter Act. The committee first conceived the idea of merging the administration of water rights and the oversight of water quality. And the State Water Resources Control Board, as you know, was created as the vehicle to implement that concept. At the time, there were high hopes that the beneficial effects of creating this new body would be great. Remember, this was the dawn of the environmental era in California and the United States as a whole. In 1969, the California legislature enacted the Porter-Cologne Act. The United States Congress passed the National Environmental Policy Act, and the state followed shortly with the California Environmental Policy Act. And in Washington, in rapid succession, we had the Clean Air Act and the Clean Water Act. Expectations were really great. Unfortunately, in my estimation at least, the Water Board's not lived up to the expectations that we set. As our Supreme Court recently noted, the board is really responsible for the orderly and efficient administration of water resources and exercises the adjudicatory and regulatory functions. The board has primary responsibility for implementing the reasonable use doctrine of Article 10, Section 2 of our Constitution and the public trust doctrine. And it's also statutorily charged with ensuring that water is best developed, conserved, and utilized in the public interest. And in my view, the board has been too timid in its leadership and overall has been a disappointment. 40 years ago, I can't believe it that long ago, I wrote an article for the Ecology Law Quarterly and noted that a major problem in the administration of water rights in California had been critical issues like the potential environmental effects of a proposed diversion often were not considered in the administrative proceedings because the applicants and protestants, if any, failed to raise them. At the time, I suggested that because the board needed to consider a far greater range of factors in acting upon applications than it had in the past, it had the authority to deny applications to appropriate water that conflict with the public interest in environmental protection, information regarding environmental factors, clearly had to be obtained by the board staff if the board was to carry out its responsibilities properly. Of course, today there's a much greater chance that a nonprofit group dedicated to protecting some aspect of the environment will step forward to take up the banner of environmental protection when the matter comes before the Water Board. As just one example, in 2003, the board issued a decision involving permits on the Lower Yuba River, in which the board relied on the public trust doctrine as the basis for revising the minimum in-stream flow requirements of the permits to protect fish habitat in the river. The impetus of that decision was a complaint filed years earlier, by a coalition of fishery groups, one of which participated in the evidentiary hearing before the board. However, we cannot and should not expect the burden of raising these issues to fall primarily on the private sector. Even with the greater environmental awareness and activism that exists today, I believe it remains critical for the Water Board to take a more active role in applying the reasonable use and public trust doctrines, as well as the statutory public interest standard of its own accord, not waiting for a participant in a proceeding to raise them or advocate a particular application of them. More than 50 years ago, the predecessor to the Water Board, the State Water Rights Board, referred to the public interest as a beacon light to guide the board in arriving at each decision made by it. I venture to say that today, with our greater appreciation of the need for environmental protection, the Water Board ought to consider the public interest, the reasonable use doctrine, and the public trust doctrine as a trio of beacons to guide it, shining lights. As the competing demands for our water resources continue to grow, it becomes more and more important for the board to manage, to control those resources as to best serve all the people of California. Those three beacons, the public interest, public trust, and reasonable use can and must serve as fundamental tools in the board's efforts to do so. So I encourage the board to be more proactive, more bold than it has been in the past in its regulatory functions. But if I may offer a brief cautionary tale from my own experience on the board. In 1971, when I was a member of the board, we considered a water rights matter involving the development of Rancho Murrieta, which most of you know is a gated golf course community in eastern Sacramento County. The developer of Rancho Murrieta wanted to appropriate water from the Casumis River and several of its tributary streams for purposes of various purposes, and the development plan called for the water to be stored in a number of reservoirs on the property. I believe the diversion from the Casumis would result in the river having diminished recreational value because of the reduced flows, and I convinced the board to include a condition in the appropriation that the developer make its reservoirs available for recreational use by the public. The decision was challenged, and after losing into trial court, which really got it right, they took the matter to where I now sit, the Court of Appeal. And while the court, in an opinion written by former presiding Justice Frank Richardson shortly before he was appointed to the Supreme Court, did not disapprove outright of the board's imposition of such a condition, the court decided the administrative record in the case before it was barren of evidence of ponderable legal significance, those legal words, in support of the conclusion that I just discussed. And I offer this tale merely to suggest that in its efforts to save, protect, and serve the public interest, the public trust, and the reasonable use doctrine, the board may have to develop its own record if facts are not raised by the public, by the parties or the public. Of course, had the public trust doctrine been in existence at the time of the Rancho Murrieta case, I believe the board would have had to consider its implications, and I think the result would have been different. So now, be bold, board. Keep your eye on those lights on the hill and consider in Anne's spirits what ought to be. And now I'd like to turn to the last of the three questions I posed. What can lawyers do? More specifically, how can attorneys practicing water law in California best emulate the example Anne set in her practice and help their clients achieve their private goals while simultaneously striving to achieve what is also in the public interest of all Californians? In a sense, every lawyer in private practice today already serves two masters. You have a duty to be an advocate for your client, but you also have duties to the public at large as an officer of the court. For example, under the rules of professional conduct, in presenting a matter to a tribunal, you must employ such means only as are consistent with truth. And among other things, you must not seek to mislead the judge, judicial officer, or jury by any artifice or false statement of fact or law. Obviously, the duties imposed on lawyers as officers of the court temper and condition what a lawyer may do as an advocate for a client. And so it should be. If the courts are to remain a place where we seek truth and justice and not just victory. Well, let me suggest that as a water lawyer, you play a third role that should have a significant bearing on how you practice. Not only are you an advocate for your client and an officer of the court, but you're a citizen of this great state, and as such you are one of the public, to whom the navigable waters and shorelines of California are held in trust under the public trust doctrine. You're also one of the public in whose interest the Water Board is charged with acting. Finally, you're among those for whom the general welfare, the reasonable use doctrine, enshrined in the California Constitution. That requires that water resources be put to beneficial use to the fullest extent to which they're capable, and that the waste or unreasonable use or unreasonable method of use be prevented, and that conservation of such waters is to be exercised with a view to the reasonable and beneficial use thereof. Sometimes you just have to say that over. As a citizen attorney of California, you owe a duty to yourself and to your fellow citizens to consider as Anne considered more than just the immediate desires of your clients. You owe a duty as Anne did, to seek comprehensive and fair-minded solutions for the intractable water issues that we face every day and that we will face more and more as our great state continues to grow. In fact, I encourage the entire water community, clients and lawyers, legislators and administrators, activists and citizens, ordinary people, to shed parochial, self-interested viewpoints that have too often been the hallmark of California law and policy in the past, and embrace a broader, more public-spirited point of view. You know, it's said that at the signing of the Declaration of Independence, Benjamin Franklin said something to the effect, we must all hang together or we'll hang separately. And you know, to some extent, I think this doctrine describes where we stand here in California with respect to our water issues. Well into the 21st century, we're already 10 years plus into the 21st century. We have more people and our water simply isn't there. We can come together, strive to find common ground, follow the beacons of reasonable use, public interest, and the public trust, and try to solve our water problems for the benefit of all Californians, or we can drive ourselves to ruin, economic, environmental, or otherwise, squabbling over who gets the last drop. So in memory of Anne Schneider, a great water lawyer, and even more importantly, a great citizen of our state, I urge each of you, in playing whatever role that you may play in the water law and policy problems of our time, to consider, as Anne did, not just what is or what has been, but what ought to be. Thank you.
Thank you, Judge Robie. I guess in terms of inaugural lectures and what we hope will be a really important series on water law and policy, that's about exactly what we had hoped for. Thank you very much. You discussed what you called the three beacons: public interest, reasonable use, public interest, and you told a little bit about how each of them works. In the broader water policy context, in terms of where we ought to be, how do those beacons interrelate? That's where I'd like you to spend a little time. Perhaps one way to do it would be if you could give an example of a situation in which the three beacons would not all lead to the same conclusion on a water resources policy or water management matter?
Well, I think that that's a good question. I do think that they're different, and that's why I think there are three of them. You know, the public interest is not talked about that much anymore. It comes from the water rights law, and it can be used in different ways. And I've written about this many times in my career, and people who read my stuff know what I'm going to say, and that is in the Bryant case, the quotation I gave in my speech. The board in 1959 found that it was not in the public interest to protect the salmon runs in the San Joaquin River, in fact, to permit the river to dry up. That was a public policy decision at the time, and the issue was that the CVP and its various needs were more important than fisheries in the river. So this is basically the public good determination by the board. It's flexible and it changes from time to time. So I'm sure that a decision invoking the public interest today would be different, but it doesn't always lead to the same thing that somebody might expect. Now, with regard to the Constitution, if you take a look at it and think about the words, the portions that relate to preventing waste and unreasonable use of water, these support policies for recycling and reuse. The reasonable use as the cardinal principle means that some uses may be unreasonable, like watering gophers or transporting sand, as the case is said. And also the idea of maximizing beneficial use encourages development. So the policy of the Constitution is sort of schizophrenic. It has many different concepts in it. The one thing we know we can't do is waste it. And finally, the public trust is different entirely. When you layer it over these others, it's primarily our means of protecting environmental values. You don't get necessarily environmental values in the public interest alone. You don't get it in the Constitution alone, but you do get it in the public trust. Yet even the public trust means some different things to different people, and it involves balancing. The trust value of navigation, for example, can be inconsistent with a fishery need. So even within the trust, as I think I said in the Delta cases, there is a balancing that must be done. But if you shake all these three concepts together and think about them and what they mean for the public policy of our state, I think you have a pretty broad basis for developing comprehensive management.
In effect, then, each time that the water board or perhaps a court is looking at a complex water allocation or water policy question, the balancing that you referred to is going to be simultaneously influenced by each of those three beacons.
I think so.
And the balance might turn more on one or another of those beacons in a given case.
I think so. And you know, I think that I would like to see some kind of analysis and policy discussion of how they fit together. It really is important that we have a coherent policy, and I think we have various doctrines that people can point to in some law book.